from Samsung Aquaba Edipa Ghanatube Suna Indra and NIP, BNI, BNI, or much less a comma Parliament House, so much MPs A plus Eka, so I'm going to answer questions concerning investigations via area, and I'm back to you, Mumbre, almost a parliament no more how more protection, but protection say pass it on the planet DI saying the facade of Ma, in the panel of Takunamuna, and in the Ama, Nasi, senior amount is some A plus, and any counterpart, and Parliament Eja Mudama, and I be some assisted with investigation.
Word on 3. The Speaker of Parliament, Right Honourable Alban Sumana Kingsford Bagman, has released 2 members of Parliament to the National Intelligence Bureau for questioning, but the procedure in itself has raised questions about the limits to parliamentary immunity as provided in the 1992 Constitution. That's the fundamental question on the minds of many who saw this letter from the Speaker of Parliament earlier today. We have a copy of that letter. We got extracts of that letter, the details of it. It's going to put on the screen right now, but this is it. This is what the Speaker wrote to the National Intelligence Bureau, referring to the letter dated the 25th of March 2025 in respect of a request for the release of Mustafa Yusuf, the former Youth Sports Minister, MP for Yagaba Kubori constituency, and Kwame Asari, or being popularly known as A+, the Goma Central Member of Parliament. The Speaker says, quote, "I am directed by the Right Honourable Speaker to inform you that having regard to the limitation of Article 117 and 118 of the 1992 Constitution of the Republic of Ghana, the existing protocols established with the security and intelligence agencies and also the public interest, Parliament in principle agrees to the request in the above matter." So take note of the 2 articles that this letter from the Speaker references, Article 117 and 118. We'll come back to that. According to the Right Honourable Speaker, he has directed the honourable members to make themselves available for the preliminary interaction with your officials, that's the NIB, National Intelligence Bureau officials, in Parliament on Monday, the 7th of April 2025 at 10 a.m. at the Sir Emmanuel Charles Quist Conference Room at the office of the Speaker of Parliament. The honourable members will be requested to have their lawyers present at the interaction, and indeed they've given the official contacts of the legal services to the National Intelligence Bureau, and this letter was signed by the Clerk to Parliament, Ebenezer Ahoma Jethro there. And as a matter of fact, when this letter became public, a number of things really came up. Now, you take notice of the 2 specific articles that this letter references, 117, 118. And we put out Article 117 so you understand why this has even found itself in the Speaker's letter. This is it. Immunity from service of process and arrest. I'm going to put it on the screen right, and you follow us closely. The civil or criminal process coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member or the Clerk to Parliament while he is on his way to, attending at, or returning from any proceedings of Parliament. And then you ask the question, Parliament is on recess, so then how would this apply? We're going to find out from a lawyer shortly. This essentially is what 117 says, that civil or criminal processes coming from any court or place, in this case coming from the National Intelligence Bureau, it's outside of Parliament, shall not be served on or executed in relation to the Speaker, that's number 1, or a member of Parliament, number 2, or the Clerk to Parliament, while he is on his way to, attending at, or returning from any proceedings of Parliament. This same provision in the Constitution finds some semblance in the Standing Orders of Parliament, and this is it. This is what the Standing Orders of Parliament says, and specifically indicates what exactly the processes should be. The order 24.
For a platform and some day, if you are by no, and now so able to waiting.
Of Parliament standing orders. This is it. A civil or criminal process coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker of Parliament or member or the clerk to Parliament while the Speaker, member or the clerk is on the way to, attending at or returning from any proceedings of Parliament. So taking this into consideration, then you marry that with what the Speaker has done right now. The Speaker, although gives that access to the National Intelligence Bureau to meet these members of Parliament, it is with a qualification that it must be within the presence of Parliament and then also in the presence of the lawyers of these members of Parliament. Martin Trōuble is private legal practitioner. He's joining us on Zoom right now for a conversation on this. Well, Martin Trōuble, good evening. Thank you very much for joining us here on Ghana Tonight.
Good evening. It's what I can say.
It's always good to have you. Now, and I'm bringing in on this point and the communication from the Speaker right now, taking into consideration the provisions in 117 and 118, the Speaker does give the NIB access to meet these members of Parliament, but it is within the presence of Parliament, specifically the Speaker's office, in the presence of their lawyers. How does this strike you?
Yeah, so it's further affirmation of the fact that, look, we are making giant strides in our constitutional governance. Making giant strides because, you see, I'm looking at those years where it was almost impossible to serve a member of Parliament. Yeah, Mr. Okansi, you heard me right. It was almost impossible. Listen, if an MP owed you money and you went to court, every attempt to serve the MP, you'll be told that, oh, he's on his way to Parliament or attending at Parliament or on his way from Parliament. Look, there's another case, an MP who was going through a divorce and didn't want his wife to get any of the properties. The frustration he gave the lawyers, look, he gave them a lot of headache. Every time, no, he was on his way either to Parliament or was returning or was in a committee of Parliament. Look, I can give you so many examples. So many would never be done. So looking at those years, and then today, you see, even before this particular letter the Speaker wrote, you know, earlier on, Speaker had agreed with the Chief Justice for members of Parliament to be served with court processes on certain days. That agreement, even though eventually, when it came to the 4-seat saga, in the last days, the Afenyo versus Speaker of Parliament, etc., it didn't go well. But generally, I think that system has been working. So, as I said, if you consider what's pertaining today to those years, no, this is like a U-turn. We've done a U-turn. Now we've got to the other end. It's totally different, and we've gone in the right direction. So it's good, absolutely good. So that whilst members of Parliament are attending to parliamentary business, if there's opportunity, they can also be made to answer questions. They can also be held accountable for their actions, private actions that have no bearing on parliamentary work. So it's good. It's absolutely good for us, right? That way it keeps them in check, because when you don't make the members of Parliament, etc., amenable to our court, our court's jurisdictions, etc., then it's like we are creating two classes of society, right? Which is not good. Because we say, yes, equality before the law. Yes, we reckon there are exceptions here and there. But when it comes to the MPs, considering their huge number, 270, we can't have a blanket immunity for them. No. The immunity pertains to only whilst they are attending to parliamentary business.
For a platform on Sunday, if you are by the north and now so able to waiting.
Or on their way to Parliament, or on their way back. But we've seen that even that one is proving too much for our society. So the Speaker had to agree to cut down and to say that, look, even when Parliament is in session, you can serve members of parliament on certain days, which is good. And now the speaker is giving permission for A plus and another MP to attend upon our investigative bodies, which is also a huge step forward. So it's good.
But then again, question is, I mean, the MPs, if our parliament is on recess, so just for the understanding of one watching us right now, the Article 117 is quite clear as to where the immunity applies. As parliament is on recess now, do they necessarily have to be met in parliament and at the permission of the speaker?
Well, that one, you see, it also has a relatively short history, right? Is to make sure that, so in principle, I'm in favor of it. Let me answer that way first. In principle, I'm in favor. Now, the reason I'm in favor is that, look, let's say if you went to BNI, typically, and not only BNI, even police stations, and then, you know, sometimes when they find that arresting you would make them look, like we say in Ghanaian English, some way, there are other forms of arrest. Something like once you arrive there, they are not going to attend to you immediately. Sometimes you can sit for hours, 4 hours, 5 hours before the meeting would start. So you see, and once you've gone in there, you are not able to leave. So you see, those kind of indirect forms of arrest happen. But when it's done at the in the presence of parliament, generally, well, I know they can also find ways of still delaying, but generally I think the incentive to keep the MP waiting and so indirectly arresting the MP is curtailed, because that officer leaves his office and comes to the parliament. If he doesn't want to do the business quickly and go, it means that he rather would also have his own business stalling, the investigator. But let's say if it were in the NIB premises, they can leave you waiting and be doing other stuff for hours. Then when they are ready, they would come attend to you. But generally in the speakers, in the press conference room, the scope or the opportunity to do those things are drastically reduced. So there is that efficiency. And it's good with comment about this indirect form of arrest. The police use it a lot. Where, look, and when you are with lawyer, so you be there with your lawyer 5, 6 hours, they've not attended to you. It's an indirect form of arrest. So this is a good step so that the police and NIB and other institutions will begin to look at their standard operating procedures, etc., to cut down those kind of indirect forms of
arrest.